code enforcement meeting for June 19, 2024 to order. Tiffany, take roll, or Steve?
I'll do it.
Okay,
Chance Silver, Raymond Butts,
yes.
Mark Maron, Jan Epshield,
Present.
Glenn Taylor.
Yes.
Okay. Before we actually begin the hearing, there's one administrative item on the agenda that we've got to take care of. Every year, we have to appoint, the board has to appoint a chairperson, and this is our first meeting for 2024. So I'm going to open it up for discussion by the other board members.
Nominate Ray Butts, and he continue to operate as chairman, if that's okay with you.
Yeah, I'm fine. And I was going to, if you guys are interested in it, I will accept that. So we need to do a motion for that. So you're making a motion? You have a motion. Do I have a second?
Second.
I have a second. Take roll.
Raymond Butts,
Yes.
Jan Epshield,
Yes.
Glenn Taylor.
Yes.
Okay. Before I begin the hearing, there's some rules that are conducted here at the hearing meeting that I want to go over. The first, the city of New,
Mr. Chairman?
Yes, sir.
I think that since it appears that that we have a failure to appear on behalf of the appellant, I think that we can dispose of, or not.
okay.
Oh, it's not? Okay. I,
Oh,
sorry.
Seen in a while.
Been a little waste this October.
I think you can dispose of that since we'll have a summary hearing.
okay,
But you may want to swear in anybody who's going to testify.
okay.
My
All right.
apologies, guys.
Brian, you're going to add one more person to the mark?
I'll Mark Maron, is in attendance, yes.
Okay. Okay, before we begin the hearing, and since Steve has came out and said that we can forget about all the preliminary instructions, I'm going to swear in anybody that is interested in testifying at the hearing today. And what I need to do, if you're going to testify, please stand up and raise your right hand. Do you swear or affirm that the testimony that you will present to this Newport Code Enforcement Board shall be the truth, the whole truth, and nothing but the truth, so help me God? Thank you. Okay, first case, and the only case that is brought to the hearing today is an appeal of a citation against the owner of the property, Jeff Trunick, 39 Summer Hill, citation 24100.
Mr. Chairman, just to preface the meeting, I want to clarify the role of Mr. Mayor here tonight, today. Out of an abundance of caution, and since the adjacent neighbor is a city commissioner, the city retained Mr. Meggerly as special counsel for this particular case, which is why he's here today. He is an expert in municipal law. That's his role in this case today, just to clarify.
Okay. Does the board have to make a motion and accept him as the hearing officer?
No, so he's not a hearing officer, he's acting as special counsel.
Special counsel, okay. Thanks. Okay. City would like to present their case for the city of Newport.
Sure. Thank you, Mr. Chairman. My name is Steve Meggerly. I'm an attorney licensed to practice law in Kentucky. I've been practicing law for 19 and a half years. I have a specialty in real estate planning, zoning, and also municipal legal issues. So I appreciated the opportunity and the invitation by the city manager to represent the city and present this case today. Mr. Trunick is not here, but so I think that we can go into some basic facts that are in the report. Did everybody receive my report?
Yes.
Yes.
Okay. And if anybody has any questions about the report, that's fine. I just think that we, at a minimum, need to make a record as to what happened. The property location is 39 Summerhill, which is in the Clifton neighborhood. The property owner is Mr. Jeff Trunick. 106, his address of record is 10650 Flag Springs Road, California, Kentucky. That's the address he provided on his appeal citation. The property's classification and use is as a single-family residence or rental property. And the date of the citation, I believe, was April the 12th, 2024, for a downspout violation, which is Property Maintenance Code 304-7. The city received a complaint regarding failing downspouts and water damage as a result of his failure to maintain the property according to the International Property Maintenance Code. Code Enforcement Officer Barry Shields responded to the complaint, and he found that there was probable cause that a violation had occurred. He took several pictures, which are also part of the record. During the course of his investigation and subsequent investigation by Building Inspector Mike Cronin, they determined that within the 10-day period and thereafter that the property owner had not abated the nuisance and the violations to the satisfaction of either the property maintenance code or the state or the building code. Mr. Cronin, there's evidence in the record that Mr. Cronin stopped by the property subsequent to Mr. Shields' investigation, that there were contractors on site making certain repairs. Mr. Cronin advised certain repairs that would be necessary to bring the property up into compliance, and the contractors on site did not believe that that was necessary, and they continued their work. I will also note that this property has a significant, persistent history of violations and citations since Mr. Trunick has been the owner. Mr. Trunick purchased the property in 2006, and I'll defer to the board as to whether or not this is a voluminous number of citations, but since 2006, as I outlined, this is his 21st citation. There have been 1, 2, 3, 4, 5, 6, 7, 8, 9 violations of the same nature of the same property code. He has also had 2 emergency orders and/or condemnation orders on this specific property. If we do have
Steve, what's an emergency order?
an emergency order is that if there is a life safety issue or he has flagrantly disregarded citations and not appealed them.
Gotcha.
For example, one of the condemnation orders was for failure to obtain a rental property license and allowing for the inspection that is called for in the city code. We do have the neighbor next door who also provided evidence that has been made part of the code enforcement file. And those include the fact that she has incurred significant water damage as a result. She has hired a structural engineer who made a report that also made, she incurred a design cost to repair her basement from water. That homeowner who is adjacent, she lives below grade, so any water that would come off the house and not be properly run to the street or into the sanitary sewer system, the combined sanitary sewer system, all that water comes downhill into her basement and has done so. She's also provided an estimate for work that was done when this was last flooded, that's no pun intended. When this last became an issue, she's incurred over $22,000 of damages that she has paid and incurred as a result of this ongoing persistent violation. Just for the board so that it can review this and to make this part of the record, if this is a video that occurred, I believe, after the initial citation, is that correct?
Yeah, I believe it's May 4th.
Okay.
It was Saturday.
May 4th of 2024. This was shortly after the citation was issued during I'll call this a moderate rain.
Steve, before you proceed with that,
Yep.
do you know who made the video?
The homeowner next door.
All right, thank you.
And so she's provided this to the code enforcement board.
Okay.
So this can be part of the public record of this case.
Thank you.
I say it's a little bit more than moderate.
You want to share the other videos? Might as well. Is that it? So those are 3 videos that were taken shortly after. Mr. Trunick, in his appeal statement, he did raise a kind of an act of God defense that that the downspouts operate in normal weather conditions and normal rains. So as I noted in the report that I went back and checked the NOAA Weather Service, and on the date of the citation of April the 12th, there was over a 24-hour rain period. There was 2 inches of rain during a 24-hour period. But if you go back and look at the history since Mr. Trunick has owned the property, there have been at least 6 occurrences where there have been at least 1 inch of rain that is a rain that day. So I would have to argue that this is not that having an inch of rain on one day in April is not a significant extraordinary rain event.
Can I ask you one question?
Yep.
The day the video was taken, did you actually pull up the NOAA?
I did not.
Did not, okay.
I did not.
Okay.
Because it was in May. I kept my review into April.
Okay.
Because he was arguing that the rain and the failure when the violation was actually, that was an excessive rain day.
So we actually haven't had no moon, what is it called when you have a lot of rain at one time?
Monsoon.
Monsoon.
Yeah, no, we have
That's
not
it.
had any monsoon.
We have no monsoons, okay.
So, based on the facts, my report, I've talked with Mr. Shields and the homeowner next door, and based on his significant history of having 20 citations, same and similar over the entire course, we believe that he is probably an absentee landlord and that a significant fine and a referral for revocation of his rental property license would adequately address this situation here. I can talk to the board if you have questions about how I came about with the calculation of the fine and the referral for have his rental property license revoked.
Yeah, could you address that, how,
James. Go ahead, Mr. Nipshield.
What size is the vertical downspout there? Is that 2.5?
Yeah, it looks like it's a couple inches.
Maybe about 4 inches
So we
or
got,
less. They may be 4 inches or less.
so we got 2 4s coming in
Those are 4s on top.
to 1 2, and then it drops down. And on the last picture before this, it looks as if it drops down to a 1.5 bottom.
And
So, I mean, if you look at it from a basic math standpoint, there's no way it can work.
correct.
That's
And
number one. Number two, half of the problem could be fixed with a piece of sheet metal running underneath the headers up there next to the house and extending out, well, pretty much to where the pipe is, just maybe 4 inches wide, that big. Costs probably $1. Well, we'll say $5 nowadays. And it would hit it, take it down to the next level and drain it. And this is nothing more than total neglect, in my opinion.
Mr. Nipshield, I would completely agree. I'm not an expert on the building code part of this, but I will tell you that it is in the record that Mr. Cronin did go out as the city's building inspector subsequent when there were contractors on site and probably made similar statements as you just did. That's not in the record, but the contractors did not agree with his suggestions, which I can't say if it was the same. To your point, yes, this is an easy fix. And this is a simple fix that has been like this for over a decade at the subject property.
I went out and looked at the other house today, and, Beth had painted her house since I was up there the last time. It was very nice, by the way. And, this is a nice house from the outside, if you don't know the history of it. And it's in a good neighborhood. That Summer Hill's a good neighborhood. And what's this guy say about owning all this property other than writing us nasty notes in there about how he's never gonna buy another piece of property in Newport, which I think is great.
Well, I mean, that's one of the recommendations is to prevent this True Investments, his LLC, from ever buying or owning real estate in the city. But he had his opportunity to appear today, and for the purposes of the record, the city clerk did send him a notice. It was sent by return receipt with the green card. The green card was not returned to the city as a bad address. The address that he placed on his appeal was where it was sent, and he has proper notice. He did not ask for a continuance and has had no response to any of the citations. So in absentia, I think that he's waived any of his defenses that he would have made.
I have a question. Is that a two-family or a single-family home?
It's a single-family residence.
Is it being rented out right now?
It is rented out right now.
There are occupants there.
There are occupants there. And I will tell you that in my preparing the report and talking to neighbors, one of the things that was a concern was the potential to revoke the rental license and the tenants not being there. But at a minimum, I would have to say that if water is to the extent that is going downstairs or going downhill to the next door neighbors, it's probably going into the basement and creating a mold situation, which creates a safety issue for the tenants inside as well. And Mr. Trunick has not voluntarily allowed the code enforcement staff to come in and do an inspection to determine if there in fact may be other life safety issues. So I would just, yeah.
You don't have the recommendation from Mr. Cronin, what he recommended to the contractors who were up there at the time for them to do the remedy. You do have it?
So, yeah, I've been following this along, even though I've not been handling code issues for quite some time now. I have been following this one along because of the history that I have personally dealt with in code with this property owner. So the contractor that was hired had advised Mr. Trunick against his method of repair, which was essentially to replace the gutters themselves and tie into the existing downspout system that was in place. They had indicated to Mr. Cronin that that would not be sufficient to correct the problem. The solution bear in mind that we are not in the job of designing solutions for this, but this is one of the things that is a basic principle of home construction, is you got to get the water away from the property and keep it from going on to your neighbor's property as well. And the solution is to upsize the gutters, bring down individual downspouts, and then pipe them out either to the street or into the rear away from the property, and do it in a manner that does not cause a public nuisance or a hazard to the adjacent properties. It's a fairly simple fix. However, there is some additional steps than just replacing the gutters themselves and walking away and calling it good. As you can see in the video, the small gutters that are on the building now, the roof shingles that were applied to the building have the water shoot over top and beyond the gutter, even just in what this looked like Mr. Megley said, a moderate rain. So they are going beyond that in a moderate rain. So in a heavy rain, I would imagine those gutters pick up little to nothing on portions of the building. So that was the recommendation that Mr. Cronin had indicated to me that the contractor did agree with that. And so that's kind of where we left it. Also, I was told that the next day, the contractor came back, collected his materials and belongings, and left the job site.
So we don't know if he quit or if he was fired.
I don't know that particular, but I think that
Steve, can I ask, how many properties does True Investment own in Newport?
So True Investment is the property manager.
Okay.
Mr. Trunick owns one piece of real estate in the city of Newport jurisdictional limits, and this is it.
That's it. Okay, so it isn't like he owns.
Correct.
He did at one point in time own additional properties in Newport, which was also in front of this board. However, he's divested of those, and he's just down to one.
The property owner that had the $22,000 to fix her property, was she covered by his insurance?
No.
Is that,
No, this was out of pocket for the homeowner next door.
So,
that's, how good?
I got a question about the property manager. Is the property manager wouldn't be liable for any of this either? It's just the property owner?
It's one and the same.
He's one and the same?
It's one and the same.
Two different names.
Yeah.
Okay.
He owns the property in his own personal name and has an LLC that has the rental property license, which is a separate limited liability company, which coincidentally is also him.
Steve, what are you recommending as far as total fines?
So, my recommendation based on his history is to, and let me get to this in a second.
Sure.
Okay.
I believe that the maximum fine for this type of violation under the property maintenance code is $500, but the code also permits that each ongoing day of a continuing violation that is not abated, each day thereafter is an additional, can be that maximum fine. So, yes,
In order to do that, do one of our inspectors have to visit the property every day?
no. No. And Mr. Shields did go back 10 days later from the date of the citation, and it was not abated. So, and the city code also allows that if there is a history of significant violations at the same property or throughout the city, it's 32.99B, it allows you to increase the fine to an amount that you feel is reasonable based on his prior history, either throughout the city or at the subject property. So my recommendation of the $5,000 fine is twofold. It is based on his history of having 21 code violations, several which are of the same nature at this specific property, and the fact that 10 days had passed, more than 10 days had passed, and he has not abated the nuisance, so each day it could be another 500 maximum fine. So either way you want to cut it, my recommendation is based on those two things, that a $5,000 fine is reasonable, with the caveat that when he receives the findings of fact, that if he does abate it in a manner that is satisfactory to code enforcement staff, that the fine be reduced to $1,000. And that if he doesn't abate the nuisance, that a $5,000 lien be placed on his property. The second remedy is that this board can make a recommendation that probable cause exists, that this is a neglectful absentee landlord, and to have his rental property license under True Investments be revoked at a subsequent hearing. You can't do both at the same hearing the way that the code works. So, Mr. Trunick, if you make that recommendation, that would go to the city manager. The city manager and his code staff would then issue a new citation to revoke his rental property license, and then he would have the right to a hearing before this board.
In your opinion, this is the way I understand it, we're better off revoking the $5,000 and going to $200 a day, right?
He's saying 5,000 total.
Do that?
Can you say that again?
What I'm thinking, my logic, it's not gonna take him any time to blow through the $5,000. He's not gonna get this thing fixed. He hasn't done it all this time. And if we go the 200, but he lets it go, then I think he's gonna get the message quicker, especially when it surpasses $5,000.
Well, I'm asking that you levy a $5,000 fine today. And
See what he responds, how.
and see how he responds.
Right.
And if he responds appropriately within 30 days, then then the board has given him grace that the fine is reduced, because I will tell you that you have a significant amount of paperwork. You have had multiple times that staff has been out there, and you've also had to incur the cost of non-city staff to put together a report and do another investigation, which because he's in fact been the proximate cause of this, I think that he should be responsible for a minimum of $1,000 instead of the taxpayers of the city of Newport.
So he has in essence, if we move forward on this, he has a $4,000 incentive
Yes.
to fix this within 30 days. If he doesn't respond to this, it kind of gives this board and the city an idea of what the next steps can be.
Right, and I would say that if you do make a motion, that it should be for the $5,000 fine and a referral to the city manager to revoke his rental property license under True
So
Investments.
we can do both those things in the same motion?
Yes.
Okay.
Now, rather than just fine him, can we go ahead and revoke his?
No, you cannot.
Cannot do that.
Because he has to receive proper notice
Okay.
and have an opportunity under procedural due process to have a meaningful time and opportunity to be heard to, plead his case on why his rental property license should not be revoked.
So after the 30 days, if he doesn't do anything, he's fined $5,000. Okay, if he does fix the situation, he's fined $1,000. Is it the city's recommendation that even though he pays that fine and rectifies the issue, that we still continue with revoking his rental license?
I think that I would defer to the administrative staff, that if they see that he's coming into compliance and that this final hammer or the anvil dropping on him is a deterrent for him to not neglect his single property in the city, I think that could be determined administratively. But I think that you do need to, at a minimum, make a finding of probable cause that he's been neglectful and an absentee landlord to begin the process of revoking his rental property license.
Go ahead.
Is there anything that the city can do in order to help the neighbor who has acquired $22,000 at this point in time, to help them out? Does he have insurance to help them, or not proper? If it's in violation, that's a code violation, so.
I think that the property owner would be satisfied to show that this would send a message to Mr. Trunick that the city is taking this seriously, and that it is in the best interest of the neighbors and the city of the whole that he's potentially not able to hold a rental property license in the city. I think that I'm not aware of any grant programs or anything that the homeowner would be eligible for. Obviously, if Mr. Trunick was negligent, she obviously has a right in civil court to bring an action in circuit court for trespass and a whole number of things, the damage to the house next door.
But that's not something.
That's not here.
Address here.
This is an administrative proceeding. Yeah, Mr. Nipsel.
Dan?
I'm still looking at this number. We fine him $100 a day for 30 days. How much is that?
3,000.
Now, that's my math too. But if we don't do that and to give him just 1,000, then at the end of the 30 days, he's come up 2,000 less than what he could have
Yeah,
if he hasn't fixed it.
I think that it was kind of when I made this recommendation, I made it more as a carrot and the stick, is that we need to hit him with the stick, and then if he comes back, we'll give him a carrot and decrease. But it's obviously up to the discretion of the board,
Yeah.
how they want to handle this. If you think that not giving him the grace of fixing it, if he does in fact fix it, that's up to you. I was just here to make a recommendation based on my review of the facts and what I think.
If I could interject for just a second on, just echoing Mr. Meggerly's recommendation. City staff concurs with that recommendation, that between the $5,000 fine being placed on the property and the addition of the threat of action against the rental license, if it goes to a point of revocation of the rental license, then that's loss of revenue, which could be add up very, very quickly. Not that that's the goal, but for the city, as this board knows, the goal is not to collect or generate revenue out of these citations, but it is to use as a tool to get a property owner to comply. Between the two of those things and the carrot that is in the recommended motion, if the goal is to get this fixed so that there's no further damage. So most people would look at this as an opportunity to, well, I'm gonna hurry up and fix this and get this resolved as quick as possible. But it still leaves a fine levied against the property as well. But it would also then resolve the rental license action as well. So the city concurs with Mr. Maggerly's recommendation.
So let me ask you, if we find him 5,000, he gets the repairs done within
30
the
days.
30 days, can he come and appeal that $1,000 fine?
No.
No.
If the board makes the decision tonight to craft the motion in the way that Mr. Meggerly is recommending, then that $1,000 fine would be essentially the minimum
Okay.
that he could get out of this for.
And one other question, there's
Yes, sir.
21 violations. How many fines have been brought against him on the 21 violations?
Several, which
Several
he's
have-
just paid the fine
He just paid the fine.
and
so
went on with his business.
The money didn't matter, and it might have been $100 or
It may have been
500.
I haven't gone through all of them, and I didn't make that as one of my boxes in my chart, but I think that some of the fines were like $30.
Oh, okay.
So,
Did he have to pay for the appeal for today? Did he
yes.
have to pay a $500?
I'm not, how much is it?
I'm just curious.
No, for a
Code, no.
citation appeal, there's the threat of additional fines if you appeal, so there is that possibility, but there is not a fee.
So he
application.
hasn't paid anything so far on this?
No.
So we could fine him 5,000, and can we have him pay for the $500 meeting for tonight? 5,500?
No.
No? Okay.
Yes.
I'll make a motion to the effect that we follow the advice of our legal staff combined with our code enforcement group and access the maximum that you feel is the best thing right now.
Well, Jan, we still have witnesses that have to,
Oh,
might
no,
want to testify?
I think we have put sufficient evidence in the record.
Okay.
Mr. Chairman, my other thing is there have been several documents. I would ask that the staff report that I wrote, the photographs from Mr. Shields' visit on April 23rd, 2024, the videos that you've seen, other photos that you've been given that were taken by the homeowner next door, her structural report, the photos of her interior basement showing damage, and her bid from Jayco totaling $22,000 be made part of the record in the event that Mr. Trunick decides to appeal this. So if somebody wants to,
I mean, anybody want to make a motion that we accept that,
the
all that evidence that he's presented?
I make such motion
Second?
to put that in the record,
Now,
Put that in the record.
You got a motion on the floor,
but he's got,
you can't put it.
Well, I held the motion up until I wanted to know if there's any witnesses. Now there's another motion because he has
I say
added.
you can't have two motions on the floor. man.
Well, we didn't, your motion was denied because,
oh, hold on a second, hold on. Mr. Nepschild, if you would like to amend your motion to add evidence that was presented to make it part of the record, that would be sufficient.
thanks, Steve.
Will you do that? Okay.
Okay. Do I have a second motion? Do I have a second? He's made a motion.
I'm second his motion.
Okay.
Okay. So the recommendation was was to make a finding of fact that there was a violation of PM 3047, downspouts, and a finding that Mr. Trunick is a persistent violator of the city's property maintenance code for this property located at 39 Summerhill, with a recommended fine of $5,000 based on the evidence that was at the hearing, and that if he corrects it within 30 days, the fine shall be reduced to $1,000. And I think somebody needs to say that there was probable cause to find, to refer this for revocation of his rental property license.
Dan, you want to add that to your
I'll
motion?
just add that to it.
May I make a comment?
It's up to the chair.
Yes.
What's that?
You want to come to the podium, Beth?
Yep.
Sure.
The neighbors at 39 Summerhill are excellent neighbors, they're good community people, they both work for the school system. I'm concerned about, maybe this doesn't apply, but I would hate to see them lose their home if his rental license is revoked.
You're talking about the renters?
The renters, yeah.
Renters
Yeah.
are excellent, they've been there they're good people, they're community, they work in the school system. I don't know, that's a question, I guess. If his rental license is revoked, will they be evicted?
Well, I think that the recommendation for referral to the city manager's office for the revocation of the rental license is essentially a
Message.
last resort effort to take action on this. So, but I think it's also an important part of the case to have that ultimate stick to go and deal with this if Mr. Trinick just completely fails to respond to the citation or the findings from this board tonight. So it doesn't mean that as an action tonight, that doesn't mean that they're going to be put out on the street. There's an entire process that is involved with the rental license revocation, with the ability for appeals as part of that as well. And I mean, you know, even at the worst case, there's timing for them to even be removed from the property if that was the case. So there's a lengthy process ahead of that, but I think it is an important piece of this case.
Yeah, and Beth, even if we stipulate the $5,000 and he gets it fixed $1,000, then it's rectified. But
Right.
our referral doesn't mean that the city's going to go ahead and make that decision. You know, it means that it's just our referral. Okay, but I think it's beneficial because if he doesn't pay no fines, you have that, and then he's going to have to come in and let's see if he comes in for a revocation of his rental license. And that's all you could do is you know, jab the bear a couple times and hopefully he responds.
I think it helps communicate how serious this is. And as he shared, there's a whole process, and they have rights as renters, then no one's gonna put a note on their door and say
Right.
they have to be out
All right.
by
just
July
wanted to-
4th or anything.
They are good people and good neighbors and good Newport citizens. All right, thank you.
Thanks, Beth. Okay,
I've got one question here.
Yes, sir.
Okay, the property itself, with the many citations that he has had and evidently hasn't been fixed, why would we let him off the hook? He's making a fortune on the house, I'm sure, rental property. You know, I mean, he's sit back and laugh at us, $1,000, here you go, that's
I think-
a month's rent, or maybe only,
To answer your question, I think this is for this case right now, and at this point, this is the maximum that we can justify.
right.
it's
if he-
$5,000.
Correct.
Right.
Okay, you know, I don't see no reason to reduce it.
No.
I think that I would say that I came up with the number $5,000 because of the history, the significant history. I mean, you all know this better than I do. I'm just sitting in a chair one day. You guys see these all the time. I don't know if like somebody having 20 citations in a 2-decade period is a lot, a little, or not much. So that was the one reason. The second reason is that the length of time, I mean, obviously, before it was cited, this existed too. So I think that, you know, if we get into dollar amounts that are in excess of $5,000, you get into the area where a court may see that that may be a little arbitrary and capricious. I think that this is one where you can justify it based on the history and the maximum fine and the fact that it existed pre, after, and he hasn't done it, and he's not even here.
I'm in agreement with you, but we do have a motion on the floor in a second. You know, so, you know, we really shouldn't be taking any more witness, but in this case here, it was an exception.
That's fine.
So I think we need to take a vote, take the roll.
All right. Raymond Butts,
Yes.
Mark Marion,
Yes.
Jan Upshield. Yes. Glenn Taylor.
Yes.
Ask for a motion to adjourn. We have no
Yeah.
business tonight.
Yeah.
Sorry, Mr. What I will do is I will type up a written findings of fact and conclusions of law and tender them for the chairman to sign,
Okay.
which advises Mr. Trunick of his appellate rights. He has 30 days from today or the receipt of the findings of fact and conclusions of law to file an appeal in Campbell District Court. And I appreciate the opportunity to do this for you all today.
Thank you.
Yes, sir.
Appreciate it.
Did a very good job.
Thank you.
Okay. So we got a motion to adjourn?
Motion to adjourn.
Okay. All in favor?
Aye.
Aye. Thank you. Is that mine?
That was sitting there already.
That's mine.
Yep.
Yeah. All right, thank you.
A lot of
A lot of trees.